Good morning, everyone, and welcome to the first session of day 2 of the Frontiers in Environmental Law Colloquium. It's delightful to be here. I can see we've got a lot of people coming into the webinar now, so we'll give you a minute or two. But my name's Alice Fleavy. I'm a PhD candidate at the University of New South Wales, and I'm delighted to be the chair for this session. Really looking forward to the presentations that we have lined up this morning. I think we will jump into it because I know there's lots to get through in this session and we want to have as much time for questions as possible. So welcome again, and welcome to our panelists, and welcome to all those joining us via the webinar. I'd like to begin by acknowledging the traditional custodians of the land from where we're all calling in this morning. In my case, that's the Dja Dja Wurrung people. I'd like to pay my respects to their elders, past, present, and emerging, and honour a culture that has lived sustainably with the land for over 60,000 years. It's a delight to chair this session this morning on reframing human-nature relationships in environmental law. I really think this is one of the most important questions that we as environmental lawyers and scholars face, and I'm really looking forward to hearing the 4 fascinating discussions that we have lined up that treat this topic. How the session is going to run, I will introduce each speaker briefly as they're about to present, so speaker by speaker. Everybody has 15 minutes to present this morning. For the information of the panelists, I'll turn my camera on and show you a 2-minute warning when you've got 2 minutes left, and at 15 minutes I will interrupt you to make sure that we have enough time at the end for questions. We are planning to have the time available for questions, and participants in the webinar can put questions into the Q&A box, and then we'll be able to direct them to the panelists when we get to question time. We'll have questions after all 4 speakers have presented, and I think it'll be a fantastic discussion at that point. So without further ado, I'd like to firstly introduce Anne Cliquet, presenting a paper by Anastasia Telesetsky and Afshin Akakavari titled "A New Principle on Ecological Restoration to Restore Ecosystems and Human-Nature Relationships in the Anthropocene." Professor Dr. Anne Cliquet is a professor of International Environmental and Biodiversity Law at Ghent University in the Department of European Public and International Law. Her research is situated in the field of international and European biodiversity law, focusing in recent years on legal aspects of ecological restoration. She's also been conducting and supervising research on themes like climate change and nature conservation, gender and biodiversity, the legal protection of urban biodiversity, and marine nature conservation legislation. She's teaching courses on international and European environmental and biodiversity law, law and ethics on marine nature conservation, international law and sustainability, and public international law in general. So take it away, Anne.
Thank you very much. I'll share my screen. Let me just see whether or not this is working. Okay, can you just confirm if you can see my screen?
Yes, we can see.
Okay, thank you very much. And thank you very much for the introduction. And like you said, this is a presentation that I prepared with my 2 wonderful colleagues, Anastasia from the US and Afshin from Australia. So we came up with the idea on a new principle, a legal principle on ecological restoration. And we first mentioned it in a book we wrote a couple of years ago on ecological restoration in international environmental law. And we elaborated on the idea in a recent publication that was published in Restoration Ecology. Now I have to warn you, this is a new idea and we're still developing our thoughts about this. We are having plenty of discussions. We already received some feedback both from lawyers and from ecologists. So we're still developing the ideas, and we really look forward to the comments that we'll get from this colloquium. So please feel free to give any comment and suggestion that you want. So what are the questions we would like to address today? Why do we need legal upscaling of ecological restoration? Why do we need a principle in order to do this? What does a principle mean on ecological restoration? And what can you do with it? And then final question, can it save the world in the Anthropocene? So there we go. Why do we need legal upscaling of ecological restoration, well, then we have to have a look at the current legal regime. And although we have legal duties, obligations, soft law instruments, policy targets, and so on restoration, we consider them to be rather inadequate. We have, just a brief overview, we have predominantly quantitative targets on restoration. We have no definition on restoration. Also, the targets, the obligations that exist, see a lack of implementation. Also, we see that mostly the obligations, the targets are vague. We have no concrete targets or guidelines on where and how much to restore. And even when governments conduct restoration activities, we often see a lack of ambition for restoration. And this is something particular for under climate change. We see that there's recently more and more attention also for restoring ecosystems, but there the focus is mostly on forests to the expense and neglect of other ecosystems. So that was.
And sorry, just to interrupt you very briefly, we can't see your slides moving. So sorry to make you pause there, but if you maybe want to move them along in the PowerPoint, we might be able to see them as you speak.
Okay, so you're still on my first slide?
Yes, that's right.
Okay, I'll stop sharing and I'll try to do it in another way. No, that's not a good one. Let me see. Let me try again.
That looked good, what you had. That looked like it was on the...
Yeah, but I'm not sure that you will then see me moving. Okay, I'm just gonna move the slides. Is that better?
Yeah.
That
okay,
looks
great.
perfect.
Okay, so I was sort of here. No, I already covered this one. That I also covered. Okay, here I'm back to my story. Why do we need a legal principle on ecological restoration in order to do the legal upscaling? Well, we have, of course, we have principles, we have other instruments like rules and standards. And the reason why we chose for a principle is because, of course, in the hierarchy of norms, of legal norms, this is on top of things, and the principles can guide the development of rules and standards. And rules and standards, of course, can further implement the principles. So that's why we chose to work out a principle first. To give you an example on what this could look like, if we compare it, for instance, to the preventive principle, there we can have rules, obligations, prohibitions, an obligation to protect a certain part of the territory as protected area, a prohibition on non-deterioration, and we could have standards, quality standards, for instance, to reach a certain favorable conservation status for certain species. If we would do the same for the principle on ecological restoration, we could have an obligation to restore protected areas towards full recovery. We could have a prohibition on deterioration after restoration. And for standards, we could have standards of best practice, how to conduct restoration in a certain qualitative way. Obviously, we will need a combination of both principles and rules and standards. Now, I would just also like to point to the difference between what we are proposing as a new legal environmental law principle and the principles that already exist on ecological restoration. And I can refer to the principles and standards that were developed by the Society for Ecological Restoration. Of course, the biggest difference is that these standards and principles are voluntary, and what we aim with this principle is to translate these principles, these non-binding voluntary principles, into a binding legal principle. Now, obviously, also the principle on ecological restoration doesn't come out of the blue. It builds on other principles, and the idea is also that it would help to realize those principles. And I just give a couple of examples. We can refer to the Stockholm Declaration already a long time ago. There they said, already mentioned the word restored. The Rio Declaration also said states should cooperate to conserve, protect, and restore the health and the integrity of the Earth's ecosystem. It also relates to other principles. For instance, in an example of regional law from the European Union, we have in the Treaty on the Functioning of the EU, it's mentioned that the EU's policy on the environment shall aim at a high level of protection of the environment. So the principle of ecological restoration could help also to make this more concrete. If we look at the relationship with some other environmental principles, obviously we have the precautionary principle, which comes first in time. Then we can move to the prevention principle, and we see the restoration principle as a principle of last resort. So, but what do we mean with the principle on ecological restoration? Well, first of all, maybe we have to explain why we chose for the terminology on ecological restoration, because also we see quite often the wordings of ecosystem restoration. And we have to say there's not really consistency in the terminology that's being used. I already mentioned the Society for Ecological Restoration, so they use the word ecological. Whereas if you look at the UN Decade on Ecosystem Restoration, there they use the word ecosystem. Also, if you look under the CBD, under the Convention of Biodiversity, we see that they work on ecosystem restoration. Now, if we look, for instance, at the what is mentioned in the UN Decade principles, then we see that they use ecosystem restoration, but ecosystem restoration includes ecological restoration. So it seems that ecosystem restoration is broader. And the reason why we actually then chose for ecological restoration is also based on what the SCR principles and standards say about it. They say, well, of course, the two terms are used interchangeably. However, ecological restoration always addresses biodiversity, conservation, and ecological integrity, whereas some approaches to ecosystem restoration only focus on the delivery of ecosystem services. So that's why we have a preference for the ecological restoration. Now, for now, this is our sort of working definition of what we mean with the principle. It provides that the highest level of ambition possible should always be pursued in ecological improvement of degraded, damaged, or lost ecosystem along the restorative continuum in order to reaffirm and repair ecological values and also human-nature relations. Now you see in our definition that we refer to the restorative continuum, and I would like to draw your attention to that. That's a concept that also has been developed by the Society for Ecological Restoration. And they made this beautiful scheme out of the restorative continuum concept. So what you actually see is that you can start with very minimal actions, reducing societal impacts, then improving ecosystem management towards repairing of ecosystem functions. So then we're talking about remediation and rehabilitation. And then we actually come to the real ecological restoration, which starts from initiating and then going to partial and fully recovering of native ecosystems. So it's only the last three categories that we really talk about ecological restoration. The other activities we would rather call sustainable land use management. Now, the aim of our principle on how we see it is that we should have a highest ambition level possible. So what we actually want is that we keep moving towards the far right end of the restorative continuum. That's where we want, as far as possible, get through, to have a partial or full restored, recovered native ecosystems. Now, so that's the ultimate aim. However, we also realize that it will only be possible everywhere. So for certain systems, this will not be possible to get a full recovery of native ecosystems. For instance, urban systems, agricultural lands, forestry, they will not be fully recovered. But we also want to have a good quality in all of these different steps in the restorative continuum. So also there, we need a high ambition level. What we mean with ambition level is both on ambition for quality and quantity. Quality, then we talk about integrity, complexity, resilience, and nativity. And quantity, of course, is the area that we want to get restored. So this is the ambition level. Now, if we combine this, then So we've got a combination of the two. We have to keep moving towards the right end of the continuum, and we need a high ambition level in every step of the continuum. Now, when we were discussing this, we were talking about the ideas of what does the principle mean. And one of the words that kept on coming back was, we have to keep moving, we have to keep moving. And it made us think of King Julian, I like to move it. So that's what we actually want to do with the principle of ecological restoration. We want to move it to the far end of the continuum. Okay, another use of the principle in ecological restoration is that it should help to overcome all the barriers, because we know there are barriers, legal barriers, social barriers, economic, financial barriers, ecological barriers. So the principle should help to overcome all these barriers, but also at the same time use all the opportunities that are presented to do ecological restoration. So this is also an important element. So maybe just a little bit of summary here, the core elements, some of the things I already mentioned. We need policies and activities to achieve the highest level of ambition possible. Ambition level is both on quantity and on quality. We need to do this in every step of the continuum, but also try to move as far as possible to the end of the continuum. Restoration, because we talk about ecological restoration, it's more than restoration for ecosystem service purposes. Also important is that we should have no backsliding after every step of restoration that we take. And then, of course, an important element is that the principle is grounded in reaffirming or repairing relations between humans and non-humans. So what will we be able to do with the principle? I think that we can do a couple of things with it. For us, the use is that it would avoid setting the pure quantitative targets as we've known now in law and in policy. We also want that it avoids activities that do not really qualify as restoration, planting monocultures, for instance. We want to avoid greenwashing restoration activities that are called restoration, but that are not restoration activities. The restoration principle could be used to set ambitious targets on how much and which restoration to be done, but also on how to conduct restoration activities. We, of course, will use it in order to further develop international law, but of course it would also have an impact on domestic law. It can guide national laws and policies and restoration plans. It can go beyond existing offset regimes, and obviously it can also be used in courts. So I come to my final question. Will it save the world in the Anthropocene? Well, first of all, I have to be a little bit negative on this. Of course, there are lots of hurdles. It's not yet a recognized legal principle. Even if it was already recognized as a principle, it will need further application and interpretation. And obviously, as we've seen with other environmental law principles, this can lead to loads of discussions. Think about precautionary principle. We can fill a whole library with different views on what this really means. And this would lead to discussions among lawyers, but also amongst ecologists. Also, if we would like to apply this in courts, also there the application and the interpretation is quite uncertain. Again, referring to the precautionary principle, we know quite a strong application at the EU level, but rather a weak application at the international court level. And of course, it would be in addition to other principles.
You've reached 15 minutes, Anne, so if you could wrap it up, that would be great.
I will wrap it up. The other principles also did not prevent further biodiversity and climate crisis. But to end on a positive note, will it make a difference? We think that it can, yes. And why do we think so? It helps create a mind shift. It creates awareness raising that not every restoration is ecological restoration. It enables a dialogue. It can direct governments, but also scientists, NGOs, practitioners, courts, and it can build restoration practices. So thanks for listening, and I look forward to the questions and the discussion.
Thank you very much, Anne. That was wonderful, and thank you to your co-authors as well. I'd just like to remind everybody that if you have questions, don't hesitate to put them in the Q&A box. We're going to take questions for all panelists after everybody's spoken, but please pop your questions in as we go along. And if you could make clear who the question is for as well, that would be excellent. We're going to move straight on to our next speaker, Nicole Graham, presenting her paper on property rights and shadowlands. Dr. Nicole Graham is Associate Dean Education at Sydney Law School. She teaches and researches in the fields of property law and theory and legal geography. Nicole's research addresses the agency of law in landscape change through the exercise of property rights, such as the right to farm, irrigate, mine, and deforest. She's written on the relationship between property law, environment, and culture through the lens of the concept of place. With Professors Margaret Davies and Lee Godden, Nicole is undertaking an ARC discovery project entitled Property as Habitat, Reintegrating Place, People and Law. She's also working on an ARC discovery project with Associate Professor Robin Bartel entitled Tenants of the Soil, Adapting Agricultural Land Ownership in Australia. Nicole also researches the role of legal education in addressing climate change. She's received teaching awards for her work teaching property law and is recognised as a highly effective first-year law specialist. Thank you very much, Nicole.
Thanks very much, Sarah. I will share my screen now, and I'd appreciate if you could let me know if you can see it. Okay.
That looks good.
You can see it? And can you hear me as well?
Yeah, all looking good.
Great. Okay, so Ninari Nyalawanyan, Mari Bujari Gadi Nuada. This is the Gadigal acknowledgement of country, the very beautiful Gadi country that I'm presenting to you from. So I would like to start, I forgot that I did this clever thing, by saying that in English common law, land was always regarded legally as very distinctive and complex. It always was a separate standalone category. And the doctrine of estates meant that land was not actually owned. It was not owned in an absolute way, for example, in the way that property was owned, because land was not the same thing as property. And many English common law historians say that the most striking feature of English land law was the absence of any notion, overarching notion of ownership. And at that time, land could sustain multiple overlapping claims by many individuals and casual and regular uses by many others. But with the transition from feudalism to capitalism, the long separated legal categories of land law and property law gradually merged so that land was increasingly regarded as an object of property. The change from land law to property law, referred to in property theory as the dephysicalization of property, is one of the most powerful contributions that modern Anglophonic law has made to anthropogenic environmental change. Dephysicalized property is a theoretical model, and it's used to foreground the abstract legal right as the true object of property. And what that means is that rights can arise over any valuable subject matter. Dephysicalized property relations have facilitated the forced removal of peoples from their traditional lands and the fragmentation of the lands themselves into component parts. The late, great, wonderful Australian environmental philosopher Val Plumwood describes the diasporas and the deforested, mine-drained landscapes of dephysicalized property as shadow places. And she says shadow places are thought to be separate from legal property relations. They're just the separate side effects, the externalities. But shadow places are not actually in real life physically or materially separate from the property relation. In fact, they constitute the material basis of your right to property in the first place. I argue that dephysicalized property rights is not really a viable model of property beyond those early discounted 16th, 17th century worldviews of abundance and plenty from John Locke and others. When we take into account environmental scarcity as a fact, global conflict as a fact, it's just no longer possible to rationally defend and reproduce this model in the research and the teaching and the practice of property law. So let's talk about this theory a little bit more. Dephysicalized property is basically a three-step transition. It goes from land being the basis of social and political identity in the feudal period to land as a thing or an object of property in the early capital period, and to now land is just completely irrelevant to property relations, because what is the object of property now? An abstract legal right. So both physical and abstract levels is where this transition from property as land to property as a right emerges. Firstly, at the physical levels, we know that enclosure and colonisation were sustained periods of violent land taking and resistance. And we know that the moral rationale of this period was to dispossess people of their lands and disrupt long-established legal relations, relying on ideas of improvement and improving waste and turning things into productive landscapes. The diverse feudal relations of people-place relations were homogenised into a single national imperial discourse of property as an abstract legal relation between a person and a thing. The adoption of the word thing removed land as a specific place from this legal model, and it just substitutes it with any non-specific object or thing that is commercially valuable and can be legally alienated. And by the 19th century, markets in new intangible commodities, such as company shares and copyright, became property also. And Jeremy Bentham described property not as a relation between a person and a thing, but a person and a right. And his intention was to extend the source of capital from land and its products to legal rights themselves. We call that the person-person model, where land is completely gone from property theory. So this dephysicalization process was confirmed by 20th century property scholars who confirmed that property is a vacant concept, that property is an illusion. So that's the theory done with. What about in practice? Dephysicalization is not just a theory, it's a practice, and that's where we as environmentally minded people should pay attention to property. Dephysicalized property is reshaping human society, it is transforming people-place relations, and it leads to broader anthropogenic environmental change of an adverse kind. It dispossessed human communities, it displaced those communities from their lands, and then what that means is that the laws that those communities had that were place-based, knowledge-based laws, are also then taken out of the legal model. Entire landscapes are then misread, misunderstood, neglected, and damaged by newcomers. Dephysicalized property by design is supposed to be applicable to any valuable commercial right. It can facilitate the exchange of capital in any form. One of the earliest consequences of this versatility was the fragmentation of places, complex places, into separable resources. So the solid, the liquid, the gaseous parts of landscapes were legally distinguished and then physically extracted and removed. So for example, in the United States, you get property rights allowing landowners to extract oil and gas from the land they owned, even though such deposits obviously traverse property boundaries. And that model quickly led to the exhausted pool of oil under some areas of land and led to enormous waste. In Australia, we can see the same thing happening when we unbundled legal rights to land from the water flowing across the land. Water licences that were once tied to land ownership could be alienated and traded. And now that the total quantum of water available for trading is highly contested, we know that water markets and property in water is problematic. So dephysicalized property has been instrumental in the dispossession of human and non-human communities. I'm thinking especially of koalas, and the disentanglement of integrated ecologies into separable natural resources and eco-services. Its manifestation, its manifestation in the accelerated exhaustion of oil and gas deposits, the collapse of aquatic ecosystems, and exponential biodiversity loss are examples of maladaptation, as Jan MacDonald describes it, of this hyper-abstract legal model to specific physical conditions. Very interestingly, you will remember from your studies of property law that alienation is regarded as key to property rights. You have to be able to alienate them or sell them for them to be valuable. But the process of alienation depends on, first, the fact that humans were entangled with places and all of the life in those places. So if we alienate the living processes of which we are a part, we usually end by alienating ourselves. By dephysicalizing property's objects, it makes it possible to disown the material costs and effects of the alienation of people-place relations. And the result is that nature is alienated and physical and biological balances are violated. In 1855, that's a long time ago, and we're just still not learning, the American agricultural chemist George Waring decried ecological losses to the soil. And he explained that soil quality cannot be isolated from the vegetation that soil supports. His conclusion was that the industrial scale agriculture going on that he saw in America in the 1850s was robbing the earth of its capital stock. He informed the research of German soil scientist Justus von Liebig in 1862, who identified that the elementary soil nutrients of nitrogen, phosphorus and potassium were being taken out of the soil and sent to the cities in the form of food and fibre, where they ended up contributing to pollution rather than being recirculated into the soil. And the result was the systematic robbing of the soil of its nutrients. Now, Karl Marx was in Germany at that time, and then later in England, and he read Waring and Liebig's work, and he incorporated this into his own analysis of industrial agriculture and land use practices. And he observed the alienation of what he called, quote, the metabolic interaction between humans and the earth. In his analysis, the rupture in the material relationship between humans and places could be traced directly to the expansion of private property, large land holdings and industrial scale agriculture. Now, economists have identified the concept of ghost acres, phantom lands, shadow ecologies, ecological displacement, and I think we're all aware of the concept of ecological footprint. In different ways, these academics from a multitude of disciplines have come to the same point, which is to recognise that there is an impact of consumption and subsequent waste discharge by converting impact variables into a single unit of land. So I would like to add to this group of scholars over the last 50 or so years, Val Plumwood. Now, she's got the concept of shadow places, and what she does in her paper, she contrasts the world's nice north places to the world's shadow south places. And she says, well, the nice places are where we enjoy the fruits of our labour, but the shadow places are where the labour is expended and waste is deposited. She said shadow places are where the disowned externalities of nice places sit. The places that take our pollution, our dangerous waste, exhaust their own fertility, destroy their own indigenous and non-human populations in producing our food, our nice food. And all these places, she says, we must own too. So towards this goal, a lesson from the Indigenous model that Plumwood encourages us to consider is a form of land ownership in which economic rights of production and consumption that arise from a parcel of land are actually aligned with responsibilities of care for that same parcel of land. And so to conclude, Waring, that American agricultural scientist, Waring concluded that man is but a tenant of the soil and he is guilty of a crime when he reduces its value for other tenants who are to come after him. Through the analyses and insights of these scholars and many others, it is possible to appreciate how dematerialised modern people-place relationships are in our legal discourses today. The simplicity of the dephysicalized model of property masks a dynamic and relational nature of landscapes, and it pretends that humans are independent of landscapes. This model encourages the displacement of its risks and costs to correlate shadow lands. The latest contribution of this scholarship is from climate science, which tells us that even if modern land law was successfully reformed to position people as mere tenants of the soil, well, that lease is pretty short. I concluded my book Lawscape by saying if we want to know how to change our property law, we have to look no further than the landscape itself, because it's the landscape that reveals our place in the world and the opportunities and limits of our connection with it. No property regime lasts forever. As we begin to reconceptualise property relations in the Anthropocene, we can learn critical lessons about the failure of the dominant model of dephysicalised property by paying closer attention to its shadow lands and catching up with scholarship in our own culture dating back over 150 years. Thank you. Oh, and I should just say one last thing, that all of that is written up in a chapter which I'd be happy to share with you, and I'm sorry I skirted over it.
That's wonderful. Thank you so much, Nicole, for that fascinating presentation, and also for keeping to time so beautifully. I'd just remind everyone again to pop their questions in the Q&A, and we're going to move on to our third presenter this morning. which is Justine Bell-James discussing ecosystem services in the Anthropocene. Dr. Justine Bell-James is an associate professor at the T.C. Baird School of Law at the University of Queensland, with expertise in environmental and climate change law and climate change litigation. Justine's research focuses on legal mechanisms for protection of the coast under climate change, incorporating both human settlements and coastal ecosystems. She currently leads an ARC discovery project considering how coastal wetland ecosystem services can be integrated into legal frameworks. Justine is also an expert on legal mechanisms to facilitate blue carbon projects in Australia and internationally, and she was involved with the development of a blue carbon methodology under Australia's Emissions Reduction Fund. Justine's work is highly interdisciplinary, and she's an affiliated researcher with UQ's Centre for Biodiversity and Conservation Science. Her recent collaborations and consultancies have involved colleagues from science, industry, NGOs, government, and legal practice. Thank you very much, Justine. Over to you.
Thank you, Alice. All right, so let me just share my screen. All right, can you see that okay, Alice?
Yeah, that's looking good.
Great, okay, please just let me know if we're having any trouble moving through the slides. I know that was a bit of an issue in the practice. All right, thank you very much for that. And may I just start today by acknowledging the traditional owners of the land from which I join you today, the Yagara and the Turrbal people, and acknowledge their elders past and present. And I'd also just like to briefly acknowledge the ARC. So as Alice mentioned, I hold a discovery project, which is looking at how to effectively integrate the ecosystem services model into law and policy, particularly in the coastal wetlands context. So I think it's fair to say that the ecosystem services framing is something that I'm quite partial to. And this made me think a little bit when I read the call for papers, because it asked us to consider how environmental law can shift to what we can do for nature rather than what nature can do for us. And the argument that I would like to make today is that the ecosystem services framing is compatible with such a shift, and it can assist us with doing good for nature. So what I'd like to first do today is just briefly address the fact that ecosystem services is a concept which is not universally embraced. And I have written a paper on this recently that I'll reference at the end if you'd like to read further. But the argument that I make is that it doesn't need to be this black and white ecosystem services versus nature dichotomy, and that we can use ecosystem services in an ethical way. And I'd also like to argue that ecosystem services is fundamental to achieving the kind of large-scale ecological restoration that is critical to the health of our planet. And again, focusing on coastal wetlands, because that's really my area of interest. All right, so that should be on the next slide. Please just pull me up if it's not. So look, I'm sure I'm speaking to an audience here who's very familiar with the concept of ecosystem services. It's something with a long history. It developed through 70s, 80s and 90s, and the really seminal Millennium Ecosystem Assessment in 2005 really solidified ecosystem services as a concept in environmental law and policy. So in a nutshell, ecosystem services are the benefits that people and humans obtain from ecosystems. So if we use my coastal wetlands example, coastal wetlands like mangroves and salt marsh store carbon, and they're very effective carbon sinks. They stabilize shorelines, which will become more important under sea level rise. They provide habitat and nursery habitat for fish. They improve water quality through binding sediments and filtering the nutrients as well. And they're really important culturally in a lot of cultures and important places for recreation as well. So there's a whole host of services that are provided. So ecosystem services is a concept that has significant support in the conservation field, and it's something that is used a lot with the scientists that I work with. And as an environmental lawyer, ecosystem services is something that I suppose really attracted me to work with, because it places nature on the same plane of comparison as other sorts of development. And I came to this from the perspective of seeing nature often sacrificed in development decision-making. So a decision maker would be presented with an application for some sort of development that would deliver very clear and tangible economic benefits, and then have to compare that against the loss of nature that was often described in a fairly intangible, fuzzy sort of way. So it was comparing apples and oranges. And I saw ecosystem services as a way to compare apples and apples, I suppose. So looking at the benefits to humans from both options. And I think this is important because we know that ecosystems like coastal wetlands have historically been incredibly undervalued by humans. So 50% of the global extent of coastal wetlands were lost during the 20th century. And a lot of this happened before the true value of these ecosystems was realized. And today, wetlands continue to be threatened by activities and phenomena, including fishing, aquaculture, clearing and development, pollution and climate change, and they're disappearing at 3 times the rate of terrestrial forests. So there's a strong argument that wetlands certainly aren't valued as highly by humans as terrestrial forests. So quite simply, there are huge parts of our population that just do not appreciate or value wetlands for their intrinsic value. And my argument is that the ecosystem services framing is a way to communicate value to all sectors of the community in a way that can make sense within their particular set of personal values. But look, as long as ecosystem services has been around, there have been debates as to its appropriateness as a conservation concept. And the debate, in a nutshell, is whether nature should be valued for what it is or for what it does. So the concepts of intrinsic versus instrumental value. And this is a debate that continues, and there have been the emergence of a lot of new concepts over the past decade or so, like rights of nature and wild law and earth jurisprudence, that have really renewed calls for appreciating the intrinsic value of nature. So my argument is that the ecosystem services concept can be used in environmental law in an ethical manner and in a way that promotes doing good for nature. And there's a really useful quote that I came across in writing my paper by John Piccolo, where he said that I've seen no environmental philosopher argue that a pluralism of viewpoints is unwelcome in solving our current ecological crisis. And the opposite has been the case, in fact. And I've also been really heavily influenced by the work of J.B. Rule and his 2015 paper, which was actually called In Defense of Ecosystem Services. And he describes himself as a member of the radical middle and says this isn't about compromising between the different sides of the debate, the left and right, or whatever you want to call it. It's about challenging their views and coming up with alternatives that work better, and ecosystem services does that. So in making my argument, I'm certainly not attempting to criticize the substantial and the very worthy work on the intrinsic value of nature and things like the rights of nature perspectives. And I think these are concepts that really should be integrated into any approach and can be used as a really useful handbrake on something like ecosystem services to make sure that we use it ethically. But I also come to my work from a really pragmatic perspective. And again, to quote J.B. Rule, he says, this is a classic case of not letting the perfect be the enemy of the good. And in the context of having really conservative governments, I query whether we have time to implement approaches that are purely based on the intrinsic value of nature within the timeframe that's needed to stop catastrophic global environmental change. So ecosystem services can perhaps be a step along the way and get us to consider nature at least on the same level as development in decision-making processes. So just going a tiny bit further here, and again, this is referenced in a lot more detail in the paper I'll point you to. So Jacques et al. Argue that juxtaposing an ecosystem services perspective with an ethical perspective on nature is not useful. And they say that this rests on overly narrow interpretations of ecosystem services and ethics. And I think it really comes down to what you think of ecosystem services as meaning. And at a really fundamental level, ecosystem services are ubiquitous and impossible not to use to some extent. So if you are currently breathing right now, which I hope you all are, you are benefiting from the filtration services provided by forests. And if you have eaten food today, which again, I hope you all have, you've benefited from the pollination services provided by bees. So it's preposterous to be completely opposed to the use of ecosystem services. But there's certainly a real jump from those sort of fundamental services all the way through to outright commodification and trading of nature, with quite a few stops along the way as well. So I think it's really valuable to view different applications of ecosystem services on a spectrum. And I think we'll all have our own individual subjective line at which we might see this concept as crossing an ethical line. So for you, it might be anything beyond that fundamental use of nature. It might be when money gets involved, or it might be when nature becomes a tradable commodity. So I think it's just important to acknowledge that we all have that different line. And there's a few other really interesting papers that summarize the various critiques of the concept. So the papers by Luck et al. And Schroeter et al. Are two particularly good ones. And with some overlap, they talk about things like the anthropocentric framing of ecosystem services, things like monetary value commodification, equity implications, and the normative nature of the concept. So quite a bit of overlap there. But really broadly, you can boil it down to two things. There are those that are in opposition of ecosystem services as a concept fundamentally, and those who are in opposition to the separation, monetization, and commodification aspects of the concept. So look, I'm not going to get into this in a lot of detail, but the point that I just want to make is that it's not a black and white issue. Ecosystem services doesn't have to mean what we can get out of nature. It can be a really effective way of doing what we can for nature, but communicating the value of nature in a way that can appeal to all different sectors of the community and their own values. So doing what we can for nature is really important, and I think restoration is something that's already been raised today. And it's a key goal across the globe, wherein the UN's declared Decade on Ecosystem Restoration, with the aim of supporting and scaling up efforts to prevent, halt, and reverse the degradation of ecosystems worldwide. And arguably, this is a real shift from environmental policy in the past. So we've looked a lot in the past at protection, which can be quite passive. It can just be setting land aside and sitting back. Whereas restoration can often involve much more human input. And my argument is that when you're trying to get people to actively do something for the environment and actively engage in restoration, the ecosystem services framing perhaps becomes even more useful. So moving to the marine context where I do the bulk of my work, restoration has been really slow to occur, particularly in Australia, and it's really challenging to undertake. And I've referenced a recent paper that I worked on, Shumway et al., where I worked with some colleagues from science and the Nature Conservancy, where we looked at what the problems are with undertaking restoration in Australia and overseas as well. And one of the big problems is that we don't have legal frameworks that are fit for purpose. So we've got proponents having to engage with systems that were designed for development and having to apply for development assessment permits in order to do restoration. And it's expensive and it's time consuming and it's really complicated. So why would anybody want to do good for nature when it's so complicated? And how can you get somebody to invest in doing this? And how do you convince somebody to give up a lawful land use to allow natural processes to occur? And it just seems to me that it's really unlikely that large-scale restoration will occur unless you've got nature valued in such a way that's meaningful to the people that need to invest or give up such a land use. Sorry, I can't see the chat, but I'm guessing I'm running out of time. So I'll just really quickly touch on blue carbon, which has been a key focus of mine for quite a few years now. And it's really exciting to me that we finally have a blue carbon method under the Emissions Reduction Fund. So the scientists that I work with identified removal of artificial mechanisms that restrict tidal flow as a sensible starting point for a method. So we've got a lot of land, particularly in Queensland, that's farmland that's been converted to agriculture through these artificial mechanisms, and it's choked out coastal saline wetlands from the landscape. And if you remove these artificial mechanisms, they can recolonize, and we can get all the wonderful benefits you have from having saline coastal wetlands. So we're now at a point with the methodology where appropriate projects can be accredited and can be eligible for carbon credits. So a lot of the people that I work with are now in the scoping phase for a number of potential projects, and we're working with governments, landholders, and traditional owner groups to try and get these projects up and running. And just another point I wanted to make is that there is a lot of work happening at the moment, particularly in Queensland, around things like carbon credits being assigned to traditional owners in order to provide a direct economic benefit. So look, yes, it is ecosystem services. There's some monetization involved, although arguably not outright commodification, but it's driving restoration and it's delivering other environmental and social benefits as well. So look, I just wanted to conclude by posing perhaps a bit of a provocative question for the discussion. And that's, if an ecosystem is restored and we've got good environmental co-benefits that are delivered and the benefits are delivered in an equitable way, does it matter if the framing is anthropocentric? And I'd really like to hear your views on that. So look, I think I'm probably out of time. My baby's actually crying down the corridor, so that is a good time for me to stop all around. So thank you very much.
Thank you very much, Justine. You were perfectly in time. You hadn't even reached your 2-minute warning, so no worries about that. But thank you for that fascinating presentation and really interesting questions posed, both in the context of the other presentations and also questions for us all to reflect on, I think, as we go into the discussion. We're now going to move on to our final speaker in this morning's panel. I'm delighted to introduce Michelle Lim, who will talk about multi-species responsibility and responsibility in hyperconnected times. Dr. Michelle Lim's interdisciplinary scholarship occurs at the intersection between biodiversity conservation and sustainable livelihoods. Dr. Lim's work focuses on futures-oriented biodiversity law research aimed at advancing equity and sustainability under conditions of unprecedented environmental change. Dr. Lim was a fellow on the Global Assessment of the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, IPBES. She was also an author of the IPBES IPCC Joint Workshop Report, the first ever collaboration between IPBES and the IPCC. Dr. Lim sits on the editorial board of the Australian Environment Review and the advisory board of AMBIO, and is also a board member of the National Environmental Law Association. Dr. Lim was awarded the 2021 Law and Society Association of Australia and New Zealand Publication Prize for a published scholarly article or book chapter for her publication in the Griffith Law Review, Extinction Hidden in Plain Sight, Can Stories of the Last Unearth Environmental Law's Unspeakable Truth? Very much looking forward to hearing from you this morning, Michelle.
Thanks, Alice. Warami, I speak to you from Wallamada and Darug Noora, the unceded occupied lands of the Wallumattagal clan of the Darug Nation. I recognize First Nations peoples as the first storytellers, the more than human scholars, philosophers, scientists, and practitioners. Pay my respects to First Nations elders, past and present, who have sustained and continue to sustain land, waters, country since the beginning of time. So perhaps what I'm about to talk about should come with a trigger warning, 2 trigger warnings. Trigger 1, I will celebrate the diverse and plural. Trigger 2, I'm also going to be talking about feelings, on how and why we can and need to bring emotion into revisiting and rethinking what's possible for our planet. What I'll also be arguing is that most forms of scholarship don't allow us to engage all of our faculties, in particular our capacity to feel. So why don't I just launch into some slam poetry? Are you really going to do it? Do I? Just bust a rhyme? Yeah, why not? They're all my friends. But you've never done this before. Why don't you just, kind of lead into it or something? Okay. So I'm in the early stages of writing a book. The working title of the book is Reimagining the Laws of Nature, Stories of More Than Human Worlds in Hyper-Connected Futures. And this builds on the work that I was encouraged to do by Ashin and Katie Wollaston as we developed this special issue on extinction for the Griffith Law Review. And I somehow managed to sneak a novella about endlings into a law journal. And then Liz Fisher kindly asked me to contribute a comment to the Journal of Environmental Law and to participate in an associated workshop on different voices, different knowledges. And there I built on the endling piece and wrote a comment more focused on this idea of fiction as legal method and highlighted more explicitly the importance of challenging the way we write as scholars. And in that piece, I draw on Rowana Gonsalves, who speaks of creative writing as this possible tool of subversion, this way of generating new knowledge through the exploration of power, desire, and change. And I refer to Manyara Milkoreit, who emphasizes that fiction writing allows us to engage all of our emotional, intellectual, philosophical, and spiritual capacities. And I cite Sophie Chow and Dion Inari, and Sophie, of course, being the final panelists tomorrow. And they talk about how stories can make us believe in and achieve better shared worlds. And the shared worlds they're talking about are, of course, the multi-species worlds. And then in the workshop, I spoke of my mixed heritage, my family stories, and how this relates to issues of different voices and different knowledges. And the wonderful Loretta Ferris, which many of you know, she was at the workshop and she made this really beautiful comment, which I'll probably remember forever. She says, and also bearing in mind that I've known Loretta for more than a decade. And she said, when I was speaking of my own stories and using fiction and different ways of writing, she felt she was seeing all of me for the first time, even though we've known each other for so long. And so coming back to this book I want to write, I've made this really conscious decision that the book needs to be very me. I mean, that might sound like really arrogant, but I think it's important that I think about what it is I can bring to these discussions we need to have about how we think differently in our very changed world. But the two disciplines I come from, science on the one hand, law on the other, in many ways they are me because I am them, but they're not all of me. They cannot be all of me. And in particular, because these disciplines don't allow you to feel. And Claire Minogue has written this wonderful book on scholastic affect. And I was talking to her about it. And one of the things that really resonated for me is how she describes how for most of us, our scholarship is being done in drag. That is, we're writing in a way which impersonates that of the white male. Not that there's, of course, anything inherently wrong with being white or male. It's just a lens to the world that cannot be completely me or completely any of you. And I've found that in playing with writing more creatively, I've found all these thoughts from my subconscious, from my past, from my childhood, all these songs, they appear. It's a very different form and experience of what we normally do, where we know explicitly where each idea comes from. And as we're preparing for the colloquium, which of course has responsibility as its theme, this coincided with Omicron entering New South Wales. And if you're from this jurisdiction, you'll be very familiar with this language we've all been told about individual responsibility when it comes to the pandemic, which clearly requires a collective government response. And in the way I'm sure all of us do, many of us do, we draw parallels with the pandemic, its causes and the responses to it, and the links to global urgencies around sustainability. And as all this was going on, I was also reading Amitav Ghosh's newest book, The Nutmeg's Curse, which also examines the more than human and the agency of more than human elements, such as this virus, which we've all come to know, hopefully not too well. And also in this discussion in The Nutmeg's Curse, Ghosh does this wonderful job of weaving the root causes of unsustainability, not only with neoliberalism, but with continued colonialism. And there's this fascinating discussion of human migration and the often false narratives that surround them, which made me think about the migration of my ancestors. So my dad's parents moved from Sato in southern China to Malaysia. My mum's grandparents, maybe 150, 200 years ago, from the UK to what's now known as Australia. And I was thinking about this migration and comparing that to the ease with which I've hopped from place to place around the world in our hyper-connected world. And thinking about the beautiful work which Nicole's just described in terms of how dephysicalized property means this huge disconnect between the value of property on the one hand, condition of land, and thinking about how Dr. Jo Ray last night in the keynote echoed this level of discontent. And what Nicole was talking about just then, these issues of abstraction, of alienation, in terms of land. I feel that in a lot of the discussions about the Anthropocene, the similar abstraction and alienation occurs in terms of humans. And we see this so much in the pandemic with the huge inequities across the world, whether that be around vaccine sharing or the access to health, and often very much coming back to, on the one hand, the neoliberalized approach, but on the other hand, how alienation of humans leads to this othering, and coming back to environmental discussions, almost this recolonization when we talk about conservation, which ignores relationships and agency across human and multi-species worlds. So this book I keep talking about, it's going to include a discussion of law, but also ways to think beyond existing laws, including through challenging the forms through which we engage in scholarship, such as through storytelling, fiction and non-fiction, exploring my family histories and presence in order to imagine possible futures. And in the book, I argue that in these times of planetary upheaval, we need to engage all of ourselves and all of our emotions. We need to feel our grief and our anger, but it's joy, hope, love, and play that will enable us to imagine and reach towards those worlds beyond. And the book's going to include, and I haven't obviously got a publisher yet, but this is the plan of what the book's going to include. Yes, legal scholarship, but engaging with the literature, but also forms of creative writing, such as this spoken word, which I will share in the 5 minutes I have remaining. I call it Out of Time, ? Black, rectangle, silver, circle, black hands trace a silver face. In my childhood home, my grandmother's clock hangs in a case. When it works, a silver pendulum swings back and forth. Tick, tock, tick, tock. My grandmother, I should call her Ama. It means, after all, Teochew for grandma. She was my father's mother, Ama. It sounds fitting, and yet other. She is my grandmother. I know her not, but I can imagine, and you can't make me stop. From that photo, I recognize features from my twin sister's face. Funny how image connects us across time and place. Lately, I've been thinking about Ama. What makes her tick? All the stories she'd stock. Would she say it taboo to speak about clocks? Tick, tock, tick, tock, tick, tock, tick, tock, tick, tock, tick, tick, tock, tock. Ring our phones, the new pocket clocks, alarm sounds, but nobody blinks. Someone else will deal with it. Also, we think a rate, a pace, a planetary acceleration that some have called great, a pursuit of growth that does not abate, speeding up the now, before and yet to come, yet always too slow on real work to be done. Lately, we've been thinking about curves, the ones we're meant to flatten to give us more time, bend a biodiversity curve to conserve more than our kind, exponential curves of development. We hear countries boast, yet for 50 years, the meadows sing of the limits to growth. Lately, I've been thinking about this moment in time, the best of times and the worst of times, a billionaire made every 26 hours while a virus takes what we thought was ours. Lives, livelihoods, life disrupted. Symptoms of this world constructed on falsehoods that we could have it all, focus on the individual, now ignoring the full individual responsibility in a time of great responsibility, where children learn not only the ABCs, but also if today is Alpha, Delta, or Omicron, keeping them from the swings and seesaws and from grandma's house at Christmas time. At this time of me, myself, and mine in this world of accelerated histories and accelerated time, I am told if I just tread lightly on this earth, the woes of the planet would just disperse individual responsibility in a time of great responsibility, yet no one responsible. Just tread lightly, apparently. Go on, give it a go. Tiptoe, 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 tiptoe. Tipping point, crash, unprecedented is the cry as the records are slashed. Individual responsibility in a time of great responsibility, yet no one responsible. Is it too late to hope, to speak of joy? No, not which you buy, for no shiny new toy can be the antidote we need in our souls that return to a present where knowing is whole. Is it too late to imagine worlds other planets which phallic-shaped vessels may conquer? No, this rock, our rock, that we care with and not smother. Not just a rhyme, didn't we call her our mother? Thank you.
Thank you so much, Michelle. What an amazing way to finish an incredible series of presentations this morning. That was spectacular. Thank you. We're lucky to have some time left with all our presenters this morning for them to answer some questions. So again, I'd encourage you to pop any questions you have into the chat. We've already got quite a few into the Q&A, sorry, not the chat. And we've already got a few lined up. So I'm going to try my best to share them around between all four panelists. And once again, would like to thank you all for your contributions this morning. They've been enlightening and enriching and certainly given me much food for thought, and I'm sure everyone else on the webinar as well. So I'd like to start off with a question for Anne. There were quite a few, this combines a few questions that have come through in the Q&A about the approach to securing a new principle for ecological restoration in law and in international law. There were questions about whether it needs a new instrument, what types of efforts need to be made to bring this into fruition, and also what the relationship of this new principle may be to existing instruments, for example, the IUCN World Declaration on the Environmental Rule of Law. So if you'd like to comment on that, that would be great. Thank you.
Okay, thank you very much for these questions. Well, on the process, of course, of getting such a principle as a legal principle, we realized that we're not naive about this. We realize that this is something that takes time, and it needs sort of efforts coming from all kinds of directions and gradually start to build on this, and that hopefully it will be picked up by governments, by NGOs, and finally end up in some kind of legal form. And preferably, of course, we would like to see it first maybe in soft law, but finally ending up in some hard law. One of the ideas we already talked about was in our publication that I mentioned, was that we should have a protocol to the CBD on ecological restoration, where this principle could be at the start of this protocol. But before we get there, we know that this will take time. What we actually are now trying to do in sort of to get the story going about the principle, we're working together with SER, Society for Ecological Restoration. We gave a presentation. They were really enthusiastic about it, and they really want to work with it. So we just submitted a note to them on how we see this, what could be possible. One of the ideas we have is that we could maybe have a side event at the next CBD COP. So these are just ideas, also working together with organizations like IUCN and so on. So that's just a couple of ideas on the process. Will it pick up on other principles like the ones that were mentioned by Judith on the IUCN World Declaration on environmental rule of law? I checked the principles that you mentioned, and obviously it strongly relates to them. And one of the principles is mentioning to restore the integrity of ecosystems. Obviously the principle just sort of hooks into these already existing principles. what we hope to achieve with this principle is that we get even more into detail, and that our thoughts are much more detailed on how to really have this high quality restoration. So much more than just mentioning that we should restore something.
Thank you very much, Anne. We'll go to a question for Justine, which is it's asking if you could comment on whether you think human obligations towards nature could be incorporated into the ecosystem services concept. So contemporary conceptualizations consider pollination by bees or carbon capture by trees as ecosystem services, but what about the practices of care that humans, and particularly Indigenous and local peoples, engage in to ensure the vitality of the environments in which they live? Do you think that the ecosystem services model could be integrated with a sort of stewardship, rights of nature approach to environmental governance?
Thank you for that. Yeah, look, I think that would be the ideal if we move towards a concept that involves both rights and responsibilities. And I think, again, that sort of shows me sitting where I am in the middle. I'm not all about rights and I'm not all about responsibilities. I think something that involves concepts of reciprocity would be the best way to go. And I noted that David in the question that he posed talked about Indigenous relationships towards nature. And I think that's a really good model, where it is one that recognises that there are things that nature does for you and there are things that you do for nature, and it's that symbiosis that's really important. And that's something I think that's looked at in some of the places that ecosystem services law is going in Australia. Like if you look at development of methodology on savanna burning and carbon credits associated with that, that's kind of tapping into some of that knowledge that's been around for a really long time around how you can best manage the environment. So it's a slightly sort of long-winded way of saying yes. I think that if there's some way that we can move towards integrating everything, that would be the best way to go. But also, I think, as I've said before, I come at this from a really pragmatic, this is how I think we're going to inch things along in the short-term perspective, but moving towards that would be a really good long-term goal.
Fantastic. Thanks, Justine. The next question we'll go to is one for Michelle. And it's a question about whether you can expand a bit on responsibility and its relationship to responsibility.
Thanks, Caroline. And I know your name's Alice, who's just asked the question, but the question's from Caroline. So yeah, thank you both. So part of the work that I've been doing that builds on some of the concepts that come from the IPBES global assessment is this idea of telecoupling. And when I first presented at a Frontiers Colloquium, the Frontiers Colloquium in Tasmania about telecoupling, Phil, who I know who's on the line now, made fun of me of like, what's the name? Gwyneth Paltrow, and it's unconscious uncoupling. Well, it's nothing to do with that, but it's more about how telecoupling is about how interconnected the world has become. So we're familiar with concepts such as globalization, which is the connection across social economic systems across the world. We're also very familiar with the way in which biophysical systems are incredibly connected across the world, whether that be climate, oceans, et cetera, et cetera. So what telecoupling highlights is, well, actually the socio-ecological and biophysical systems themselves are so interconnected that it doesn't make sense to think about them separately. So in the context of biodiversity, the result is that the impacts and causes of biodiversity are increasingly coming from sources which are far, far away, whether that be oil palm on Borneo due to supply chains from other parts of the world. And part of the link between responsibility and responsibility is thinking about how in this hyper-connected world, yes, it creates all these challenges of management and in our context for regulation, but also creates all these opportunities, for example, the internet and social media campaigns in terms of the internet and how that has in some way help to facilitate more sustainable use of oil palm. So all these fantastic things that come about from our hyper-connected world, which can be used, I suppose, for good rather than evil. But unless we, and obviously the link there for me is because they sound similar, but unless we deal with the underlying issues and framings and values in terms of our relationships with nature, no amount of technology, capacity to respond, etc., is going to make that huge difference, that transformative change we need across our socio-ecological systems to get to more desirable worlds and more desirable futures.
Thanks very much, Michelle. Thank you all for these excellent questions. We've got a question for Nicole as well. And I know I can see you're potentially halfway through typing an answer, Nicole, but maybe you'd like to share it with everyone. It's a question about what you see as the key elements of a new property regime for land.
Yeah, thanks very much for the question. Look, I think Justine and other Queensland legal scholars have suggested something really helpful and important and powerful probably 10 years ago now, Justine, and that's to use the land title register more comprehensively. So, you know, when I teach real property day one, hour one, law students learn that the register is everything you need to know about properties on the register. There are equitable interests lurking behind it, but, you know, the register will prevail. So strong is the investment of the state in the register that we've created the assurance fund, so that even if there are equitable interests in the land, the register will prevail and will just compensate those equitable interests. So if that's the power that we're going to accord to the land title register, let's make fuller use of it. I think Justine and other Queensland scholars' contributions about registering, or putting on the register, I should say, the duties and responsibilities attaching to a parcel of land is a fantastic idea. It's within the system that's already there. And if I might take the opportunity, Alice, to pose a counter question to Justine's paper, and Justine probably knows that we're on different perspectives on this. Justine, you used time as the basis or the premise of your rationale for, look, we don't have time to, you know, have a revolution. We've got time's ticking. We're running out, as Michelle was saying, tick tock, tick tock. And so you're saying, so let's just work with what we've got. Does it really matter conceptually how it's framed? And I agree with you, I'm a pragmatist too, but I just wanted to ask you, Justine, with time as the premise and the urgency here, ecosystem services and the trading and the transactions around that are entirely private, right? So coming from a private law perspective, my concern is that things that are private impose no obligations. They're obligations that people choose to take up. So in terms of urgency, how can we encourage more people to voluntarily give up commercial benefits, or how can we make those benefits more commercially profitable? Because if we don't want the command and control and we want the carrots, those carrots need to be enormous given the time frame that we're talking about to get more private buy-in. So sorry, Alice, I know that was a bit unorthodox, but I didn't know how to write my question.
That's all right. It's nice to be able to have some lively interchange as well, even in an online forum. So it's good. Justine, do you want to respond to that briefly? And then I was thinking we might come back to Justine's final question and hear just briefly from all the panelists to wrap up the question and answer session. So you can all think on that. But Justine, do you want to respond to Nicole directly first?
Yeah, no, that's right. I'm so sorry about this blog, but I've got far too much solar ecosystem service in my home. Like a little bit too much of a good thing. Yeah, look, the time argument's a bit of a dangerous one, and I knew that when I was making it, because the fact we're running out of time, I think you can argue either way. It's, well, let's just do the best we can right now because we're running out of time, or it's we really need to throw everything we can at this because we're running out of time. So I acknowledge that was probably the weakest spot. They did really well to pick straight on that one. I guess what you were saying about you know, looking at this from that private law lens and moving towards, you know, incentivization and that sort of thing. Look, that's something I've been doing a lot of work on in the background lately as well. And I know that this is, very capitalist, private property driven. The work I've been doing for Nature Conservancy in particular, we've been looking a lot at how you can shift those land uses and what incentives you can provide. And I think the blue carbon methodology is a pretty good model there. And we are seeing a lot of landholders that the teams I'm working with that are looking towards moving away from cattle farming towards carbon farming. And it's still got that economic lens, it's still got that capitalist lens, but we are seeing people willing to give up industries that they've worked in to move towards things that are going to have better benefits for nature. And I mean, my query is that a bad thing, even if it has that really capitalist lens? Is that a bad thing if we're getting those outcomes for nature? So maybe that's a question back at you. And I think that's the question I posed as well. Yeah.
Well, hold that thought.
Yeah, I was just going to say,
just for a moment.
It's not bad, but it's not fast enough.
And hold that thought about framing just for one moment. There's one quick question I want to just direct towards Anne, and then I'm just going to ask each of the panelists for just a 1-minute response to that question that Justine posed around, if we get outcomes for nature and we get restoration and we get positive changes, does it matter if the framing is anthropocentric or not? But just briefly to go to Anne, a question around, I guess, the baseline that you're seeking to restore to. This is in the context of climate change in particular. Philippa asked about how this fits into your thinking about the legal principle of ecological restoration.
Yeah, thanks, Philippa, for the question. I think we can talk a couple of hours about this. Just very briefly, I think when you try to recover a native ecosystem, you look for a reference system. Obviously, the thing is, when you restore, the more you can restore an ecosystem to be more robust, to be more resilient, the easier it will be that species will be able to migrate and so on, and the more you will be able to have this recovery. But of course, it needs to be possible, and I can imagine that in many ecosystems it's still possible. You might not have a full recovery, but a partial recovery because of climate change. But I guess in some systems it will become too difficult. Yeah, and then you will not have a recovery of a native ecosystem anymore, and you might take into account the elements, the information, the knowledge that you had of what was previously there, and try to include it as much as possible, but taking into account the new elements, the new species that may be arrived there, and so on.
Thank you very much, Anne. And so just to wrap up, if just 1 minute each, we've only got a few minutes left. But Justine, would you like to start? What's your answer to the question about whether the framing matters?
Look, I think I've given my answers, so I'll let everybody else speak.
For sure. Well, is there anything you'd like to elaborate on? We can come back to you at the end if there's anything you'd like to add to what people say. Michelle, do you want to?
I think the framing does matter, and I think also that the question which assumes that continuing of framing of nature as a service will necessarily lead to the transformative outcomes we need, that I'd like to sort of like turn that back on its head. And can we assume that? Because to my mind, thinking of, and part of what I think extensions of the ecosystem services concept to things such as nature's contributions to people really touch on what Justine also highlights is not on the one hand intrinsic value and what's the other value, the monetary value, but the relational value in between. And I think that is so important. And if the question was, if we get benefits for the environment, does it matter if it's just an anthropocentric framing? I've said my response would be, can't we have this more relational framing where we think about where every species, human and more than human, fits within thinking about the world we want?
Thanks, Michelle. It's really interesting, challenging that dichotomy between anthropocentric and ecocentric, that there's other dimensions. Nicole, do you want to reflect on the question?
Yeah, look, I think yesterday at the National Press Club, we had two fantastic speeches. And in one of them, Brittany Higgins said she wouldn't care so much about the appalling language used by Scott Morrison if there were actions that substituted for those mistakes. And language matters a lot to some people and not so much to others. And I think Justine's point that if we're getting positive outcomes, does it matter how they're framed? I totally get the pragmatism of it, but for me, as long as it's framed as optional, voluntary, and it's not as commercially attractive as producing primary industry products, then the speed at which this happens won't be viable to make the difference. So yes, it's making a teeny difference, but we need a bigger difference. So I guess going back to the National Press Club thing, the actions need to be substantial and fast because we're just running out of time. And I just wanted to thank Michelle for your courage and your creativity and your talent. Your poem was amazing, and the time factor here, I think, is also foreshadowed in Anne's presentation, and the despair that all of us have, the solastalgia that we're all talking about. We're trying really hard, but the time is our enemy here. So ultimately, Justine, I agree with the pragmatic lens, but I just think we don't have time for people to opt in. We need strong public responses rather than private opt-in.
Thanks, Nicole. And you talked about consciously choosing ecological restoration instead of ecosystem services and thinking about that framing. Do you have a reflection on the question about whether an anthropocentric framing matters or not?
Well, for me, anthropocentrism means that it's the humans who give value to something. And we could do this in a very limited form, just valuing ourselves. And then I'm not okay with anthropocentrism, but if we can also value the world around us, of which we are part, and then I don't really have a problem with using anthropocentrism. And for me, this broad form of anthropocentrism resembles very much the ecocentrism as well. So as such, I'm okay with using the word anthropocentrism.
Thank you. And Justine, did you have anything you wanted to add in response?
Oh, look, I'll just, I guess, continue to state my claim as a professional fence sitter. And I was just thinking of, that meme from the taco ad where she's like, why can't we have both? And I think that's what it comes down to. Like, we're part of nature, and, we deserve a good life, and nature deserves a good life. And I think if we can move towards something that's really symbiotic, that would be great. And I certainly don't disagree with you at all, Nicole, that we need to be really scaling up and looking at this from a really public law lens as well as purely private. So I don't think we're actually too far apart now thinking in that respect. So
Well, thank you all. I think that conversation was a great way to end the session around reframing human-nature relationships in the context of the Anthropocene. I certainly, and I'm sure everybody on the line, has benefited from the insights and the wisdom that you've all shared with us this morning. It's been a fascinating and stimulating session that really, I think, gives a lot of hope for the possibility of reframing those relationships in the context of the planetary challenges that we're facing and the intricacies of environmental law. So once again, thank you very much to all of you. Thank you to the organisers for putting on this fantastic session to start the day, and I wish you all the very best for the rest of the conference and the rest of the year. Thank you again.